Okay, let's unpack this. Imagine a murder conviction. Seems pretty clear-cut, right?
Mm-hmm.
Only for it to be completely overturned by the highest court. It feels almost like a legal magic trick, surprising for everyone involved.
Definitely.
So today we're diving deep into a really recent Supreme Court of India judgment. Narayan Yadav versus the State of Chhattisgarh, 2025.
Mm-hmm.
We want to figure out the critical legal thinking behind such a shocking outcome.
Exactly. And our mission, really, in this deep dive is to get why certain evidence, even something that looks like a confession, might just be thrown out, why it's inadmissible, and also how the courts draw that fine line between, say, murder and, well, something less serious. It's fundamental.
Right. And our guide through all this complexity is the judgment itself, the Supreme Court's own words. That's our blueprint.
Our primary source.
So let's start with the basics. The case at a glance. What happened initially?
Well, Narayan Yadav, he was first convicted of murder, Section 302, IPC. The trial court found him guilty of killing Ram Babu Sharma. Apparently, there was a quarrel. Something about a girlfriend's picture.
A common enough spark, unfortunately. But then the High Court stepped in.
It did. They changed it. Reduced the conviction to culpable homicide not amounting to murder. That's Section 304, Part 1.
Okay, so a lesser charge. But it didn't end there.
No, because the Supreme Court agreed to hear Yadav's appeal. And that's significant. It means they weren't just nodding it through.
They were going to scrutinize everything.
Meticulously. Yeah. Reviewing the High Court's decision, making sure the law was applied just right.
Right. And this next bit about the FIR, the First Information Report, this is where the Supreme Court really started peeling back the layers, isn't it?
Absolutely. They pointed out the High Court's biggest mistake right off the bat.
Which was?
Relying on Narayan Yadav's own FIR, the report he filed, using that against him.
Hang on. So the statement someone makes to the police when reporting a crime, that can't be used to convict them, even if they admit things?
Generally, no. Not if it's a confession made to a police officer. Section 25 of the Indian Evidence Act is pretty clear on this. It's considered inadmissible as evidence against the accused.
Wow. Why is that?
It's a major safeguard. Public policy, really. Mm-hmm. To prevent coercion, ensure reliability, it forces the police to find other evidence.
So it's not just a technicality?
Not at all. It's fundamental. Now, the FIR can be used sometimes in limited ways. Maybe to show the person made a statement, that's conduct under Section 8.
Okay.
Or if it leads to a discovery, like finding a weapon, that's Section 27. But here, the Supreme Court looked at Yadav's FIR and said, plain and simple, this is a confession.
And therefore?
Unusable for conviction. You can't build the core of your case on it.
Okay, so if the confession and the FIR is out, what else did the prosecution have? What about, say, medical evidence, the doctor's findings?
Good question. Medical evidence, like the post-mortem report from Dr. R.K. Divya, it's crucial, no doubt. It details the injuries, the cause of death.
Very important, you'd think.
It is important, but legally, it's considered advisory. It's expert opinion. It helps the court understand the facts, but it can't be the only reason for a murder conviction.
It needs backup.
Exactly. It needs corroboration from other solid evidence.
And what about physical evidence? Or Yadav's actions, like didn't he point out where the body was?
Yes, that's conduct evidence. The court considered that. But there were problems. The panchnamas, the documents recording evidence collection, the court noted issues there. And key witnesses, the independent pension witnesses, had turned hostile. They changed their stories.
Oh, that weakens things considerably.
It does. So while conduct like pointing out the body or hidden clothes is relevant under Section 8, the Supreme Court stressed that alone isn't enough. Especially for murder. You need, and I quote roughly, cogent and credible supporting evidence.
Which they found lacking.
Precisely.
Okay, this brings us to the third big point. The High Court had reduced the charge, right? Using this idea of a sudden fight. Exception 4 to Section 300, what's that actually require?
Right. Exception 4. It's specific. It covers deaths in, yes, a sudden fight in the heat of passion without premeditation.
That sounds like it could fit a quarrel.
It could, but there's more. The exception only applies if the offender did not take undue advantage.
Undue advantage.
Yes, and didn't act in a cruel or unusual manner. All those conditions have to be met.
Okay. So in this case, was it a fair fight, legally speaking?
Well, the Supreme Court looked closely. The victim, Ram Babu Sharma, was unarmed.
Right.
Yadav inflicted multiple...
How meticulously they have to be applied. Yadav's acquittal wasn't necessarily saying he's innocent in the way we might think day to day.
No, it was about the prosecution's duty. They failed to prove the case using evidence that the law accepts, following the strict rules.
The conviction had to stand on legally sound footing.
Exactly. It underscores that convictions need admissible, corroborated proof, not just an initial statement, not just conduct without strong backup. The burden of proof is high, and the rules matter.
It really makes you think, doesn't it? How does the legal system balance this very stringent application of evidence rules? Balancing that need for justice with protecting individual rights. It's a constant tightrope walk.